Juvenile Justice Committee. This is a full committee meeting. I'm going to call this meeting to order. First, I'd like to recognize Superior Court Judge Lawton Stevens. Thank you for being here, sir. It's always great to have you with us. We have two bills on the agenda today. We have HB 507, which is by Representative Oliver. That bill will be placed in subcommittee and have a hearing at a later date. We also have House Bill 568 that we're going to hear today by Representative Dempsey. Representative Dempsey, if you'd like to present the bill.
Good afternoon, Mr. Chairman and members.
Is that working now?
I think maybe. Is it?
You need to pull it closer.
Pull it even closer. I was trying to get it close enough without.
That'll
There
work.
we go. Good afternoon, Mr. Chairman and members of the committee. I thank y'all on this afternoon for coming together to hear this very important measure, House Bill 568. And I'm joined here by Stephen Harris, legal counsel for the department, to help answer any questions that might come up, because I know many of you are the lawyers and I am not. So we will see where we go from there. Yesterday afternoon we were joined by several people who could not be here for this, and I just want to make sure that y'all are aware of that. Our juvenile court judges, Sherry Roberts from Newton County and Velma Tilley from Bartow, and Superior Court Judge John Simpson and Elaine Johnson, the Administrative Office of the Courts. So they are very concerned, and I understand that some of you may have heard from some people about this bill to help us hopefully expedite us at this late hour. We're going to talk about genetic testing. This proposal seeks to mandate DNA testing in all new child support cases involving children born out of wedlock. So it is for those specifically seeking child support. The test eliminates the potential that a non-biological father would be burdened with a court order to pay child support for a child that he later finds out is actually not his. Approximately 20% of the DNA tests conducted by Georgia's Division of Child Support Services exclude the man initially named as the father. The proposal also helps to meet the federal block grant requirements to establish the paternity of children born out of wedlock. Meeting the paternity establishment goals would allow the state to increase the amount of federal incentive funds that we receive. DNA tests, to talk a little bit about the cost, DNA tests cost $33 per person tested. The cost is significantly cheaper than private testing services. The mother, father, and child must all be tested to assure accurate results. The cost of the testing is initially charged to DCSS. If the alleged father is confirmed to be the biological father, the state recuperates the cost for the test from the non-custodial parent. If the alleged father is excluded, then DCSS may seek reimbursement from the custodial parent who named the father. Privacy, I know, has particularly been a great concern in this discussion. The department currently contracts with DNA Diagnostic Center, DDC, for genetic testing services. The standard for these are set by the American Association of Blood Banks, which also certifies the lab that will be conducting the test. While the vendor collects the test, the genetic material for the department, the vendor also trains the staff of the department to collect the samples. In some cases, most cases, it's actually a swab. The vendor provides training on the appropriate chain of custody for the samples. The clients must sign a document allowing child support staff to collect samples. Once these are collected, the agency has a strict process in place to protect the samples before they are shipped to the vendor. Samples are shipped daily to the vendor. Once the sample has been analyzed, the vendor enters the test results into a database that interfaces with the Division of Child Support Services case management system. That system is called STARS. The American Association of Blood Banks requires that the labs maintain genetic testing records for a minimum of 5 years. The vendor maintains the samples in a secure environment with limited access, and all case-specific information remains confidential with the department. The vendor documents confidentiality training for anyone who has access to case files or samples, and the only information shared from the vendor is provided to the oversight agency, the American Association of Blood Banks. This is such important legislation. I think what we have found historically is that quite often someone is presumed to be the father when they're not. Often, as our juvenile court judges have shared with me, often trying to pay child support and running out of funds to do that, they can even be incarcerated, where the problems begin to escalate and become more and more out of control. So the upfront genetic testing to make sure that that father is the father is profoundly important to the child, important to the mother, but important also to that father, that they not be caught in a situation where they are actually not the father and could really experience some very life-altering consequences as they go down that trial. Yesterday, Judge Tilley from up in Bartow County was here, and she sent me some words last night that I want to share with you, because I really think her experience in the courtroom. She is not only a juvenile court judge, but she is the legislative chair of the Council of Juvenile Court Judges. Just to read from her, in juvenile court we deal with quite a number of out-of-wedlock births. We see the harm that comes to children when the real biological father is not quickly identified, or is only identified years down the road. They often are unaware that they are not the father, and when they know, they can actually step up to the plate and assume that responsibility. Paternity is important. Finding the real father is important. Children do better when both parents are identified as soon after birth as humanly possible, so they can have a chance to grow up with at least one of those parents. The juvenile court judges have asked for this support, and also DCSS, the Child Support Commission, supports this and have given her permission to let it be known of their support as well. And with that, that tells you what the context of the bill is. I know y'all have read the bill. It breaks down very clearly and succinctly. I believe there may be some questions that we'd be glad to entertain from the committee.
Thank you very much, Madam Chair Lady. Is there any questions from the committee? Representative Rakestraw.
Thank you, Mr. Chair. So if a father has been paying child support and it's determined that he's not the father, what happens there?
Thank you. If the order was if the order was obtained by the Division of Child Support Services, then that father could make a motion to the court to either, for a number of things. For one, to forgive any arrears that have accrued, or for secondly, to stop any future payments made.
Okay. Is there any money paid back to the father that was paying for the child that wasn't his?
There's nothing in the bill that would allow that.
Okay.
And again, we leave the discretion up to the court to make that decision whether those arrears should be set aside.
Representative Quick.
Thank you, Mr. Chairman, and Madam Chair, thank you for bringing this bill. And I did hear from Judge Tilley, and I just, of course, want to make sure I'm doing exactly what she also told me to do, which was make sure everybody knew she was in favor of the bill and that the Child Support Commission supported the bill as well. I mean, I think they see it as much like their bill, which is House Bill 264, repealing administrative legitimation. They see these as sort of companion pieces of legislation, in part because the goal, as you have stated, is to find the actual father and ensure that the actual father has a role in the child's life. So thank you again for bringing the bill. I've got just a couple of technical questions on page 4 of the bill, lines 123 through 128. And I really want to just ask about the mechanism where it talks about in any case where the underlying child support order was issued by another court of the state, the movant may request a genetic test. Now, under this scenario, what I'm reading is there's an order, presumably by a court of competent jurisdiction elsewhere in the state, already in existence. How is it that we are able to affect that order by a simple motion in a new proceeding, not that underlying case? Wouldn't you have to file a motion, or what we used to file is a motion for extraordinary new trial based on the new genetic evidence, or the new evidence that that person might not be the father? I don't know, haven't done one of those in years, so I'm showing my age now at this point. But what would be the mechanism? How would you deal with this other court order?
Okay, well, specifically with line 123, at this point, the Division of Child Support Services has an open child enforcement case. So I think case in this context doesn't necessarily refer to an open court case. It refers to a case that the Child Support Services Agency is enforcing. So at this point, as you see on line 123, they can ask the department for a genetic test, and we can do that in any case that we're enforcing. And again, if there is a court case already, you have to think about that. For example, domestic relations cases such as child support, they don't really end until the child emancipates. So, for example, if an enforcement motion is made, a motion for contempt, that's considered a part of that underlying child support case. So when an order is entered and then a contempt motion is filed years later, it's actually considered to be just a continuation of that underlying case. So I think something similar would be found here. It would be a motion to set aside the prior order, similar to a motion for extraordinary relief.
But in this context, when this motion is filed for the genetic testing, what happens to the underlying order? Because presumably it could be a final order in a paternity determination elsewhere in a superior court elsewhere in the state, not unrelated to child support services.
Right. The underlying order could be set aside by the judge. If you see, like on lines 133 and lines 134 and 135, it talks about where the judge can set aside the prior order for support.
Somebody's going to have to help me here, since I didn't brush up on Title IX before we met. But wouldn't that require something to be filed? Maybe I'll call on Judge Stevens to answer on behalf of the Council of Superior Court Judges. An unlikely position I find myself in to actually make him answer questions instead of him always making me answer his questions. Wouldn't something have to be filed in the court that issued the final order in order to affect the final order?
I believe that's correct. I think you have to go back to the issuing court, get it set aside there. That'd be my opinion.
I think that's true too. I researched this issue with respect to another bill, and the general rule is that the issuing court can cite someone for contempt, and if you go outside of that court, then you have to have jurisdiction. Otherwise, there's a provision, and I think it's 19-629. I may be off on that statute. I think I am off on it, but you bring up a good question. It's a venue question, I think.
And I think also, Mr. Chairman, a res judicata issue in terms of that final order in the issuing court, because presumably we would be dealing in a different context here with collection. So that would just be my only question about it. I understand what you're trying to achieve, and again, I think it's a good bill overall, but I do think there's that procedural hurdle that we've got to figure out a way to get over at some point. Thank you, Mr. Chairman.
I would be open to any advice on language that you think might clarify that.
I think this is an issue that we're going to have to really work out, because if you have an issue in court, the initial issue in court that says that establishes paternity, let's say it's in Catoosa County, and then you go to Sumter County, they move to Sumter County and they want to collect child support at that point, and let's say it's a default in Catoosa County, then they go down to Sumter County, and that's where the person, the putative father lives. They go to enforce it. The way we have modified the law, or well, actually, the way the law stands now, in addition to the modification we've put into the statute, will provide that they can hold them in contempt in Sumter County. I think the question that Representative Quick is asking is, how do we vacate the Catoosa County order in Sumter County?
There is the other bill perhaps that passed out of judiciary last night, does that in any way help with that same issue if it passes?
Well, it helps with the enforcement and the
enforcement
contempt
of it,
issue.
not- right, but
It
not
just,
the-
right, the issue that I believe she's
Right.
bringing up is the order that's issued by the Catoosa County court would have to be vacated by the Catoosa County court.
Right.
The department could certainly bring the action in Catoosa County. If you'll note that line 132, this only applies to orders obtained by the Department of Human Services. So we are a party to that underlying order, the agency, and the agency, we operate across the state. So we could certainly bring the order in front of that judge in Catoosa County and have the obligor, if he now lives in Sumter County, we could have him serve there for the
To answer in Catoosa.
yes.
Well, and I don't think I can see, I don't see at this point, I don't recognize a way to get 5 hours away from Sumter to Catoosa without just flat out driving and doing that. So, and I don't know, I think is that your question, Representative Quick?
Yes, sir.
Okay. Okay, well, we'll just continue to work on that. I'm not sure we'll come to a resolution of that. Any other questions from the committee? All right. Anybody else would like to speak on the bill? Oh, excuse me, I have one more. Let's see. Representative Rakestraw?
Thank you, Mr. Chair. On line 52, it says the Department of Human Services shall pay the cost of such tests subject to recoupment from the alleged father. So which one's the alleged father? The one that's been paying the child support, or the one that they're getting tested to potentially pay it?
Okay, so
In those cases where you've got,
in those cases, to go back to that, it's initially charged to the department. If the father is confirmed to be the biological father, the state recuperates the cost for the test from the non-custodial parent. If the alleged father is excluded, is found not to be the correct match, then DCSS may seek reimbursement from the custodial parent who named the father.
okay. So this just talks about the alleged father. It doesn't really clarify which one.
What line was that? I'm sorry.
Well, 52 through 55. It talks about alleged father, but it doesn't say which
But
one
it
is the
says if
alleged.
it excludes, see, if the genetic test excludes the possibility of the alleged father. So that's clarifying whether the alleged father or the real father. Exclude means you are not.
Right, I
genetically
understand, but what I'm saying is you've got two people here, one that they're assuming is the father that was not, and one that they're just figuring out. So they've both been alleged at some point in time to be the father.
We would deal with those
She's
individuals.
got an answer.
Certainly.
I'm sorry. Good afternoon. My name is Tansy Gray Johnson. I'm currently serving as the Child Support Director for the state of Georgia. In response to your question, the alleged father in this particular case is the non-custodial parent that's been established under court order.
Okay.
So you have this parent that's been named by the mother, and the order, as you previously mentioned, Chair, has been established either through default or consent. So the alleged father there is the parent that's been ordered to pay child support. He may not necessarily be the biological father if the
Okay.
order was established through consent or default.
Okay, so up until that point in time where there's a new court order that says this is the father, the one that's been paying is the alleged father in this situation. You might want to clarify that a
Right.
little bit.
And so just for further illustration, if you don't mind, Chair, I'd like to use you as an example. Let's just say, for example, that he has a child support case, Mr. Weldon, and he has been paying for this child for 13 years. And this child support case that's been established for Mr. Weldon was established through default or consent order. He was in love at the time, and he signed the paperwork with no paternity testing. And then 13 years later, something happens, and the child starts looking like someone else. And he requested a paternity test on his own, a private test. And the test excluded Mr. Weldon as the biological father. So at that time, and with this bill, it will provide the child support agency with an opportunity to petition the court to set aside this order on this case, where Chairman Weldon has already been paying for a child that's not his for 13 years. And once or if the judge moves forward with set aside the order, future child support payments, and any past child support payments on that legal binding document, then the child support agency can move forward with conducting a paternity test on the biological father or the new alleged father that the mother names in order for us to locate the biological father. So we relieve Chair Weldon of his financial responsibility, his medical responsibility, and unfortunately at that point, the emotional trauma that he experiences and the child experiences has already been damaged.
Mhm. Okay, thank you. So it's possible we could get Jerry Springer to pay some? Just saying.
Well, and
We could
and
get him a gig on the show and help cover some of the costs.
And I think what you're talking about is the front end, and this is when there's already an existing child support case. It's not on the front end of establishing that.
The other question, you said in what you read, which is not part of the bill, but you said that it makes sense, something along the lines of it makes sense to get the testing as close to the birth as possible.
Right.
So I don't see anything in here that really addresses that. And is there a statute of limitations to where, we're saying after a certain age or a certain time period, you cannot pursue paternity testing?
No, paternity can be established at any point.
Okay, so that didn't change anything
No,
there.
that didn't change.
Okay, and we're not requiring it upon the birth or anything, so.
No. But I would like to add, once again, there's two focuses here. We want to make sure we get the opportunity to offer and mandate paternity testing for all children born out of wedlock where paternity has not yet been established. And this is for child support cases. So this will be in the very front end prior to the order being established. And then two, I also wanted to reemphasize that, yes, Chairman Weldon is correct where we can establish paternity at any given time if it has not yet been established. But the child support agency, we no longer have the authority to disestablish once the order has been established or once they've moved forward with signing the paternity acknowledgement form. So this is extremely important to avoid that financial and emotional trauma that's occurred to both men and the children for the state of Georgia.
So, okay, so like you're saying, in the instance where you talked about, they were together 13 years and they were in love and he took responsibility. If he signed something acknowledging paternity, that can't be undone?
We don't have the authority. That is a federal requirement to give citizens an opportunity to acknowledge paternity.
And once they do, it's their cost from there on forever and ever on that,
unless they
until they're
bring
18 or
about
whatever.
some legal action.
I think it'd take a court order
Thank
to
you.
It would.
set aside the order. They acknowledge it, and it's a statement against interest in court of law. And based upon that evidence, a judge issues an order. And then that judge the court issuing that order can set it aside.
That procedure is already
You agree with that?
established in 19754.
Okay, thank you. And then just one more point I wanted to make sure that the committee was aware of around data and the impact that this bill has. Child support here in the state of Georgia, we have a little bit more than 354,000 parents court-ordered to pay. And our genetic testing vendor provides us with reports. And in those reports, there's about 20% of the alleged fathers that you just mentioned are excluded. So without this bill, there's also a potential of about 70,000 fathers in the state of Georgia that could be named as the alleged father, placed under the court order through consent or through default, that is not indeed the biological father. So we're talking about huge numbers that not only impact our Superior Court judges, but also impact our juvenile court judges.
Representative Quick.
Mr. Chairman, I just wanted to let you know I represent you on all that if you
Thank-
needed to.
I
After all that.
I very much
Just in case
appreciate
somebody
that.
didn't know about that out of wedlock situation.
Well, I'm glad I have good representation. I have 4 cases, just we hadn't gone to the defects yet. They've been getting their support from me directly. If I could, Ms. Johnson, could I in line 52, and I don't know if you have a copy of the bill. For the record, this is LC 400879. On line 52, it reads, shall pay the cost of such, of such test subject to recoupment from the alleged father if paternity. That's on line 52. Where it says alleged father, it seems to me that that would be the putative father. You agree with that?
Yes.
So if we removed alleged and put in a putative, that would be more indicative of the situation.
I would think so, but I do need to refer to legal counsel here to make sure that there's no legal definition of putative father that.
Putative father usually refers to a father in the putative father registry who has made an effort at the time of the child's birth to register himself as a possibility of being that child's father. I think alleged father here is definitely more of a broad term because we may have fathers who did not take that step, who the mother is alleging that this is the father of the child. So I don't know if changing it to putative would create a little bit of confusion as to whether it would only refer to somebody who's been registered with the putative father registry.
Okay. All right. Thank you.
You're welcome.
Representative Chandler?
This is a question to Ms. Johnson, please. And the statement that you made a while ago before you came back up, I don't understand.
Around the data?
Yes, ma'am.
Okay, so here in the state of Georgia, we have a little over 354,000 men who are ordered to pay child support. In addition to that information, Representative Dempsey talked about our genetic testing vendors. We have DDC, which stands for DNA Diagnostic Center. They handle all of our paternity testing for the alleged fathers. The reports they have provided to our agency reflects that 20% of the men who are alleged to be the father of the children, either through applications for our cases or on our cases already, are excluded. So 20% of that total population are not indeed the biological father for those children. And we have the privilege of that information, so we know we are not obligating these men to pay child support for children that are not theirs. I was using the 20%, and applying it to our total caseload of 354,000. And without this bill, there's the potential that in the future we could easily obligate more than 70,000 men. And a child support order through a consent process or through default without having this mandated paternity testing, the impact to the state of Georgia regarding our children is huge.
Ms. Johnson, I believe there's a presumption at law that if you legitimate a child, whether the child's born in wedlock or not, or if it's through a judicial legitimation, then the child is if it is yours. And I hear your concern about the 70,000, using the statistics, but it seems to me like there's some moral responsibility of the father to be careful about the situations he puts himself in. So if they claim the children, we need to make sure they're paying child support. That's the position, I think, of the department. Wouldn't you agree?
Yes, but I would like to add, I agree 100% around the moral responsibility, and I don't want to communicate anything negative around the services, the state services that are offered. But I've been with Division for 22 years, and I've learned a lot, not only about the moral responsibility of the men, but the moral character and characteristics of the women who applies for our services. And so they, too, have a responsibility of making sure that they provide us with the correct biological father when applying for state services, especially when a legal order will be established. And as it relates to legitimation, it is just such a disadvantage, but it has been my experience in the 22 years that most of our non-custodial parents really and truly don't know the real definition of legitimation and how to go about legitimating a child and getting access and visitation to a child through the appropriate legal process. So there's a lack of education there. And you're right, there's a lot of assumption there that doesn't benefit the child in the long run if a situation arises with foster care, placement, and things of that nature. So there is just a number of factors that need to be considered.
It's just a little more complicated than what I might have said, huh?
Yes,
Or might have
sir.
considered. I think you're right.
Yes, sir.
I agree with that. Thank you. Representative Bell.
Thank you, Mr. Chair. So we're talking about who pays what. What's a dollar amount for these particular types of tests?
The dollar amount is $33 per person tested. And that's significantly cheaper than a private test would be. There's actually federal money that I believe is
Well, our share would come out of the federal payment. I think Tan can deal with this more accurately than I could.
I'm sure you guys are aware that the Child Support Agency is federally funded by 66%. So they pay 66% of all of our administrative costs. And so that leaves the 34% that the state of Georgia or DCSS has to pay. And so, for example, in paternity testing, it does cost, the state negotiated contract rate is $33 per person. So if there's only one child on the case, the feds will pay the $66, and we will only pay $33.
Father, mother, child, you're picking up one of those, or you're picking up a third.
Mm-hmm.
I was going to let my colleagues speak. We're going to share the mic. Thank you.
You're welcome.
Any further questions from the committee? All right. I think we'll take about a 2-minute break, and we will reconvene in just a second. There's a couple of issues I think we want to address with the author, and and probably the department, so we can get some language just cleaned up, and just give us about 2 minutes. We'll be in recess for 2 minutes. Come back at 2:42. Do we have anybody else who'd like to speak on the bill? Seeing none, the bill's on the breast of the committee. Do I hear a motion?
Mr. Chair, I'd like to have the motion do pass, please. Submit a motion to do pass.
Okay, have a motion do pass. I have a second?
Second.
Have a second. I hear any, is there any discussion or comment from the committee?
Mr. Chairman, I have some amendments.
Okay. Representative Quick.
Mr. Chair, just curious, is that out of order? Not so much?
No, it's okay.
Got it.
We didn't have any other, but that's all right.
Just clarifying, sir.
All right. Any motions? Okay. Representative Quick.
Mr. Chairman, amendment number 1, I would propose on line 59 of the bill to strike the word parents and insert instead any party.
Okay. For the first quick amendment, is there a second? All right. All those in favor of the amendment indicate by saying aye. All those opposed, like sign. Amendment is adopted.
Mr. Chairman, I have a second amendment.
Okay.
On line 91 of the bill,
All right.
where it says Superior Court, insert after the word superior or state, and then it would read court, and then insert that entered the order, so that line 91 would read, such motion shall be filed in the superior or state court that entered the order and shall include colon.
Okay. That'll be the second quick amendment.
And just for the committee's edification, Mr. Chairman, that's because state courts and superior courts have concurrent jurisdiction in paternity cases, so that the issuing court could have been a state court.
All right. Good call. Do I have a second? Second. Any discussion or comment on the amendment? Seeing none, chair calls the question. All those in favor of second quick amendment indicate by saying aye. Aye. All opposed, like sign. Passed. Amendment is adopted.
Mr. Chairman, I have a third amendment.
State your amendment, please.
On line 131 of the bill, on page 4, at the end of line 131, where the word is where, delete the word where and insert instead the word when.
Okay. All right. Well, we'll go back. That'll be the third quick amendment. Do I have a second? Second. Any question or discussion on the third quick amendment? Hearing none. All those in favor of the third quick amendment indicate by saying aye. All opposed, like sign.
Mr. Chairman,
adopted.
I have another amendment.
Okay.
On line 133 of the bill,
Okay.
where it says the motion to set aside paternity, insert after the word aside a determination of, so that the line reads, the motion to set aside a determination of paternity may relieve the obligor of responsibility for any future or.
Okay. That'll be the fourth quick amendment. Is there any objection to the fourth quick amendment? Seeing none, fourth quick amendment is adopted. Okay.
Mr. Chairman, I have another amendment.
Okay.
On
State your-
line 137,
Okay.
to delete the word where and insert the word when.
That'll be the fifth quick amendment. Have a second? Seconded. Any objection to the fifth quick amendment? The amendment is adopted. Okay.
Mr. Chairman, I have another amendment.
Yes, ma'am.
On line 138,
Okay.
where it now reads failure to include the Department of Human Services to insert after the word services as a party.
That'll be the 6th quick amendment. Do you have a second? Second. Any objection to the 6th quick amendment? The amendment is adopted.
And Mr. Chairman, with the assistance of Legislative Counsel, there are 2 more incidents of where when should be when
Okay.
that I'd like to amend the bill to change.
Okay, is that on line 123 and 127?
Yes, sir, it is.
Okay. And then on line 125, indicates, it reads, Human Services, comma, the movement may request. Would you make a motion to change the movement to a party? Strike the words the movement and insert in its place a party?
Yes, sir. So moved.
Okay. All right. That will be the, get my numbers right, 7th quick amendment for those 3 changes.
One comment. You just struck the word the movement and changed it to a party on line 125. The same word movement is used on the next sentence, line 126 and 127 as well.
Yeah. Okay. Well, let's get this 7th quick amendment. Thank you for bringing that to our attention. Is there any objection to the 7th quick amendment? Hearing none, amendment is adopted. Okay. Then, Representative Quick, you have another motion or amendment?
Just 1 second, Mr. Chairman.
Okay.
And that is the party or the movement? That's the movement. Mr. Chairman, ask me to move.
Because we don't want, in case, because in a case where the non-child support order was issued by a court of this state or by the Department of Human Services and is being enforced by the Department of Human Services, a party, we don't want it to be just the department. We want it to be either party, either the father. Well, we need to change to a movement or, because the movement, to me, it seems to be like it would be the department here. We're not saying the department, but if we put in there a party, then the department or the.
It is a movement. It is. We're moving.
Yeah. If we put a movement right here, I'd be okay with that right there, I think.
Yeah, I think this should be a movement. This should be such movement, and that should be a.
Okay, so 125.
125 is a movement.
Okay.
127 is such. Into is such. And 127. I guess change the to A.
Representative Quick.
Mr. Chairman, if I might make another amendment to deal with these issues we've just been discussing on line 125 to modify a party to a move-ant. On line 126 to change and delete the word "the" and replace it with the word "such."
Is there, on line 127, you want to delete the word "the" before move out and insert "a"?
That's
Delete.
fine, Mr. Chairman.
Okay, and that'll be the 8th quick amendment. I hear a second. Any objection to the 8th quick amendment? Hearing none, the amendment is adopted. Any other amendments for discussion on the bill? Okay. With respect to LC 400879 as amended, Chair calls a question on the original question. Here, and all those in favor, the do pass motion for LC 400879 as amended, all those in favor indicate by saying aye.
Aye.
All opposed, like sign. Do pass. The bill passes by committee substitute with a do pass recommendation. Having no other business on the agenda, this meeting is adjourned. Thank you.